Hello and welcome to Rights of a Free People, a program produced by the Rhode Island affiliate of the American Civil Liberties Union. I'll be your host this evening. My name is Megan Cachadorian, and I am the assistant to the director there at the office. Today I have two guests with me. To my left, Lisa Holley. She's an attorney here in Providence with the law offices of Lisa Holley. Thank you for being here.
You're welcome.
And next to her is attorney Sonja Deyoe. She is cooperating counsel, both are cooperating counsels for us here at the ACLU, and she is an attorney in Providence as well. Thank you both for being here. Some firsts on the show today. We have two first-time guests, one first-time host, so we're going to try and get through this all together. But today I thought would be appropriate. We've had a number of cases come through the courts recently dealing with prisoner rights, and both Lisa and Sonja are helping us out with those cases. So today's show will be dedicated to that topic. As Dan normally says, we flipped a coin and Lisa won or lost, but I thought it would be great for her to start off and just give us a little background about what you do and how you got into this line of work.
Certainly. I initially thought I would respond by saying that my work in corrections is what brought me here. I've had a wavy path to today. I started out my career prior to law as a police officer in Warwick, and subsequently left there and became the chair of the Rhode Island Parole Board. And I chaired the Parole Board for about 13 years, and then kind of got back into law enforcement and police work. I was the chief legal counsel for the Department of Public Safety and the Rhode Island State Police. And then I left to practice on my own. But I don't think that really answers the question as to how did I get into prisoner rights. I was thinking, driving here tonight, probably, I'm very proud to say when I was in high school, without giving away my age, I was involved in a national organization called the National Prisoners' Rights Organization, and that was at the time when the ACI was really in tumult. At the time it was prior to Director John Moran, and I was involved in a group in Providence that was calling for the ouster of the then directors. They had co-directors. And I actually had the opportunity to be on the hiring panel, believe it or not, a high schooler, to hire the incoming director, which was John Moran. So at that time, the ACI was on lockdown for months, and that was what prompted the federal consent decree. So I guess I did start my teens with an interest in prisoners' rights, and here I am. Several years later, I won't say how many, but now as a solo practitioner, I am assisting with prisoner rights cases.
I hope we were nice to you when you were on the other side of the law.
Always. Always.
Same question to you, Sonja.
Well, I guess I would describe myself as a civil rights lawyer at this point. I got involved initially with prison rights probably somewhere back in 2008. I had a gentleman who had corresponded with me who was held at minimum, was outside, and had a guard pull a gun to his head and pull the trigger. Now the gun was not loaded, obviously, if the guy's talking to me. But that's how I got involved initially. Was not anything that was anywhere near my radar. And, going forward from that, I've had a couple of cases involving inmates that were assaulted by officers, one sexually assaulted by an officer. And I don't know, I got a call from Steve maybe 5-6 years ago with respect to the civil death marriage issue, and I've been involved with you folks ever since.
Yes, it seems to have become a very busy issue area here in our office. And, oftentimes we deal with marginalized groups, people that the general public think shouldn't be having rights. Why are you helping them out? Explain to me, this is a toss-up for either one of you, why people viewing this, why our audience, why we should care about the treatment of individuals who are in our local correctional facilities, and then maybe a little bit about, the hoops that they have to go through to try and get resolution if their rights, the very few that they do have, come under fire and are trampled upon.
Okay. As far as the population that I'm dealing with, which is primarily individuals who are in high security or maximum security, these are people that are there for having committed some of the worst crimes. I mean, that's certainly true. But they still have the right to be treated better than animals. And I think that's a good analogy. For a lot of the people that I am dealing with, we have what's known as a civil death law applying to them. So effectively, we've got a statute that says you have no civil rights at all. And the effect of that is absolutely chilling. You're looking at the prison and the state being able to take whatever action they might want to with them, and our state government looking at it and saying, well, because of this statute, we can't do anything. And the implications of that are immense. There's no accountability at all. The other part of it is that to the extent we have prisoners that are being subjected to these sort of conditions, you have a situation where probably 98% of them are ending up being paroled or flattening their sentences. So we're making them better prisoners. We're making them so that they'll go out, they'll reoffend. We're not doing anything to rehabilitate. And sort of that's what's so important about this whole thing, is that you have to treat people humanely so that when they go back out, they don't do these things.
Now that civil death you talked about, does that affect everybody that's got a sentence, or is it only for certain individuals?
The Civil Death Act is applying to something like 212 of our prisoners right now. So no, it doesn't apply to everybody. I don't know the exact number, but I think there's 2,800 or something individuals that are locked up right now. But for that 212, they have essentially no civil rights, which effectively, as the statute has been interpreted, would mean that they don't even have the right to be heard on a civil complaint in state court.
Now, is that somebody who is parolable? Is that someone who's got a life sentence? How do they determine when somebody becomes civilly dead?
The statute says that the person has been sentenced to life and is being held at the ACI. So whether they get parole or not doesn't matter. Okay. And the fact of the matter is that somebody who has one of these life sentences with the ability to have parole, if they were sentenced today to that, would have the opportunity to get parole in 26 years. And in some instances less, because that statute has been increased over time. So there's a very large chance that these individuals will eventually go back out and be members of society.
Okay. And does anything, if you are paroled, does anything follow you? Do you lose rights even after you've, done your time, so to speak?
Well,
are there any things that you wouldn't be able to do? Like, I know recently we restored voting for certain individuals, with felony convictions. Is there anything else that, you've done your time, but essentially you're still being punished for it?
Do you want to do
Well, certainly with when you're out on parole, you really are an inmate in the community. I think it's very different than someone being on probation. You're still under the auspices of the Department of Corrections and the Parole Board. So things like Fourth Amendment rights, search and seizure, when you sign a parole permit, you are signing allowing the state to be able to search your home, your residence, without a warrant. So you are giving up some rights. So in that regard, there are some rights that are surrendered by being an inmate in the community. Certainly what Sonja is talking about as far as the civil death statute with life prisoners have much more serious consequences, but anybody on parole does give up some rights by signing that parole permit.
Now, in terms of wanting to bring suit, are there issues that inmates who have the ability, who are not deemed civilly dead, are there hurdles that they have to sort of overcome in terms of, you know, court filing fees or things of that nature that maybe somebody wouldn't necessarily have who is, you know, out free and able to bring a case?
Sure. One of the laws that was passed, I don't know, it was in the mid-90s or early 2000s, is the Prison Litigation Reform Act. And I think it was 96, actually. And what it says is that a prisoner has to administratively exhaust all of their remedies within the prison before they can actually go ahead and file a suit. And it also puts other restrictions on damages and things of that sort that they might be able to recover while imprisoned. So that's the first thing they have to sort of exhaust. And sometimes you will have situations where they don't necessarily have prompt decisions from the levels they take the appeals on. So, you know, you file your grievance with, say, your warden. They decide, no, we don't want to do this. Then it goes up to whoever it is that is the director. And I think there's actually another intermediary step there. So, you know, theoretically, they should be able to file suit within 30 days, but oftentimes it's, you know, more like 60. And sometimes they don't get the paper back administratively exhausting at all. Then we have the whole issue with inmates having limited funds. Unless an inmate themselves happen to have a bunch of money that was transferred into their accounts at the prison, or they've got a family member who is, you know, helping to subsidize these things, they have to file in form of PAUPUS motions to get those sort of fees and costs waived. Frequently, what the federal courts will do anyway is they will put them on sort of a monthly plan. You know, if your accounts have more than $50 in it, we're going to take $5 from you until those fees are paid. Also, when you go to do that, the federal court's going to look at the complaint to see if it even states a colorable cause before they'll even take your money and let you file it. I mean, it's sort of a really long battle. State court doesn't have that review step, but it's still the same sort of motions they have to go through to be heard.
Okay. Is there anything you wanted to add about anything we've chatted about so far?
Not about that, thank you.
Sure.
Well, I think, you know, maybe we could touch upon some of the cases that we mentioned. I know Sonja has already sort of brought up the civil death issue, but Lisa, you're working on a different issue that I think is interesting and certainly very difficult for someone who's not, you know, does not have a background in parole, probation, sentence structure to understand, you know, what has happened. So I'm hoping you'll be able to sort of break it down for us relating to that issue.
Sure, I will try. So when a person is sentenced and sent over as a sentenced inmate to the ACI, at that point, someone in the Department of Corrections calculates their parole eligibility. And I will tell you, for someone who is going to the ACI with a sentence, they know their parole eligibility date the way we know our birth date, because that's the first time, that's the first ray of hope that they have that they might be able to leave prison. And that is whether they're a life sentence or sentenced to a fixed period of time. And what we found was that recently, within the last year, many inmates have had their parole eligibility date recalculated. Some of them were thrilled because they had a parole eligibility date in the future. Now all of a sudden they've been told they're going to see the parole board earlier. Others were disappointed to learn that although they were coming up on their parole date, they were learning that they should have been seen earlier. So prompts the question, why should they have been seen earlier? Well, apparently the Department of Corrections about 10 years ago determined that they had been misinterpreting a statute. There are two statutes that are relevant in this instance, and it is when a person is sentenced with a consecutive sentence, whether it's a life and a consecutive with a term to serve, or consecutive sentences that are fixed terms. What the Department of Corrections had been doing is aggregating, pursuant to a statute, aggregating their sentences and taking 1/3 of their time and making them eligible to see the parole board. In the case of life sentences, I think Sonja had referred to a case where someone would be eligible in 25, or in cases where there were shorter periods of time. Life sentences have eligibility based on the date of the crime. So some people are serving a life sentence where they're eligible in 15 years on the life, 20, 25. So in those cases, what the Department of Corrections had done was someone would be eligible in 20 years, and if they had a consecutive sentence, 1/3 of that consecutive time would be added. And so someone would see the parole board 20 years and then 3 1/3, let's say, believing they were going to be paroled out of the institution. When they were seeing the board, Corrections was saying, yes, you're eligible to be paroled, but only to your next sentence. So I, along with the ACLU, looked at that and said, there's something wrong with this. The person either didn't see the parole board in the right time, or they have served 3.5 years towards another sentence that they haven't gotten credit for. So that was the case that we were moving forward and brought to the Superior Court to have the court look at the parole eligibility and whether or not they can aggregate, and then later, after someone has waited 20 years, then disaggregate their sentences for parole eligibility. I hope that was easy enough to understand.
And now I guess, how did we get two statutes that sort of were conflicting? I mean, I know the answer, but why don't we tell everybody how that works?
So there are two statutes. One is a statute that directs the aggregation of sentences, and then there's another statute that talks about inmates serving long sentences. So the Department of Corrections has always read these statutes in one way, and then along the way they've decided that the statutes haven't changed, but they've decided to reinterpret the statutes on their own, and they believe that they have been doing it incorrectly. So they have, changed course, and in effect, there are, we say dozens, I think it may be much more than, many more than dozens that this will impact. And when I said initially, some people were really excited because now they're going to see the parole board earlier. Yes, they will. But the caveat is they're not going to be parole eligible to the street. They will see them earlier only to be paroled to the consecutive sentence and to start serving time on that sentence. So they didn't win anything by that. Mm-hmm. The Department of Corrections is now trying to catch up for not seeing the people under their new scheme, which was see them when they're first eligible on the first sentence.
And that is, I just want to make sure I understand, that is your eligibility varies based on what your overriding sentence is?
So you have a controlling sentence.
That's what I was looking for,
and that would be, if it's a fixed term, it's 1/3 of your sentence. Unless it's a long sentence, it has to be, it's no more than 10 years, except for life sentences. Mm-hmm. For first and second degree murder. And those sentences are based on when the crime was committed, and it's either 10, 15, 20, 25 years to serve before you're parole eligible. That's all by statute.
Sure. And so our case essentially said to the department, hey, look, this is not right, and they've agreed with us to an extent.
In this particular case, we took a case to Superior Court on behalf of one individual, although we know that there are others waiting. This one individual was a specific case because he was granted parole and he should have been released to the street, our argument is, in December. However, Corrections changed and said he could only go to his sentence. So once we saw that, we took particular interest in him because he had a specific liberty interest. As soon as the date came that he should have been paroled, and they came with a parole permit for him, but it didn't say you're being paroled to Providence, Rhode Island, and an address certain, but you're being paroled to your consecutive sentence. We put in a petition for a writ of habeas corpus on his behalf. The case is still open. We did stipulate with the Department of Corrections that he should be released. However, it does not clear the way for anybody else, and we have many waiting in the wings to see how we will proceed with their cases.
So something to keep watch on.
Absolutely.
It sounds like a good case, though.
We hope
I
so.
know.
We believe that you can't change the rules of the game for these folks that have been waiting. Some of them have already served past their first parole eligibility date. And how do you make up for the time that they've been waiting to see the parole board?
Well, check our website if you're paying attention and look for any updates on that case.
Absolutely.
Sonja, I know. Sonja's got a few cases, and she, like we said earlier, touched upon one dealing with civil death. We have about 5 minutes left, so I'll ask you to run down whichever ones you'd like to chat about.
Well, I think we should talk about the Morris Rules case.
Okay.
Ms. Holley, or Attorney Holley, talked about how when she was younger, in a younger iteration, she had to do with the hiring of the director of the ACI. And I will try not to throw you under the bus terribly much, but this was a very long time ago. It was before the time I was thought of. There were these things called the Morris Rules that were put in place as a result of the riots at the ACI, which resulted in the replacement of the director you were involved in. The Morris Rules generally stated that individuals would be put in what we call solitary confinement. It's actually a classification for no more than 30 days. And that they would be entitled to a 3-person panel before they would have discipline enacted against them. So those are sort of important rights. Having 3 people make a decision that you have committed a violation of the rules is certainly better for an individual than having 1 person decide. And we have all sorts of studies and decisions and all sorts of things that say that being in solitary confinement more than 30 days is something that can be very damaging to individuals. In fact, more than 15 days can be seen to be very damaging, but for the moment, applying the Morris Rules would mean 30 days. So historically, there is a twisted litigation history. It goes up to the First Circuit, comes back, goes to the Rhode Island state courts, comes back. The long and the short of it is there's this circle that ends up being created where the federal courts refuse to enforce the Morris Rules, and the state courts say, well, they don't exist because the federal courts couldn't require the states to enact them. So earlier today, we have a decision comes down that effectively says to the Department of Corrections, look, you haven't been enforcing the Morris Rules since the mid-90s. You have 30 days to start enforcing them again. Now, ultimately, what will happen with the decision we got today is really an open question. But if it stays the way it is, 30 days from now, we have inmates that have been in solitary confinement for long periods of time. I mean, more than 6 months, sometimes more than a year, who would then be at a place where they're released from that. And that's obviously something that we have a great deal of concern and interest in. The secondary part of it is changing the disciplinary system would again be really good for a lot of these inmates, because most of the time the evidence they're found responsible for violating these policies is not that great. So that's what's going on today, and what will happen with that, who knows. As far as the civil death goes, we filed a suit on behalf of Davis and Lombardi against the governor to have that statute declared unconstitutional. That's presently pending in federal court. and there's a lot of different reasons why we say that that statute should be knocked down, including the fact that it affects an ability of an inmate to be heard in state court, which is one of their First Amendment rights. So there's that, and that's at a motion to dismiss level. Hopefully we get a decision sometime relatively soon on that.
Again, a couple more cases to keep on top of, visiting our website, but they are screaming at me from the control booth that, like that, our time is up. So I wanted to thank my guests again, Lisa Holley, attorney in Providence, and Sonja Deyoe, another attorney in Providence, both cooperating counsel with us. I want to thank you both for being here. I hope you'll come back if we have updates to the cases. I want to thank you also for joining in. If anything you heard today resonates with you, if you have any questions, our information is on the screen below. Feel free to reach out to us. Thanks for tuning in.